Hello viewers, welcome to my channel. I'm Hasham. Now in this video I'm going to explain you about the duties and liabilities of directors. The last two videos I've completed the meaning of the term director, qualification, disqualification, appointment, removal and position of directors. All these things I've explained in the last two videos. Hope my regular viewers have already watched those videos, now got the command regarding the director's position, what position he plays in the management of the company. Now this video is very important because I'm going to explain you about the duties and liabilities of directors, so watch till the end. So if you have not watched the earlier videos, I suggest you to go to the playlist of my channel, select the subject business law, select the topic that is directors, then qualification, disqualification, all these videos are there. You watch that, definitely you can be able to get the confidence on this topic. Now first of all, duties. I'm explaining about the duties of directors. Actually directors occupies a very important position in the company. The directors got immense power from the company. So when the company has given immense power to the directors, it is the responsibility of the directors to perform their functions diligently, with full confidence, not negligently. So here, as the directors possess immense power, they hold a key position in the company management. They have a lot of power because the functions of the company are performed by the directors. So law imposes certain duties upon the directors in the interest of public good and for the protection of those who invest money in the company. Because public money is involved. In a joint stock company, public money is involved. So the law has made it some compulsory duties that every director must perform certain duties to protect the money invested by the public. And breach of these duties or negligence in performing it entitles the company to sue for damages. If the directors fail to perform their duties, then the company can sue the directors for the damages made to the company. The duties of directors can be broadly classified into two categories: general duties and special duties. So in order to learn complete duties of directors, we classify them into general duties and special. First of all, general duties. Every director must perform the general duties. The duties are to act as per the AOA of the company. AOA stands for Articles of Association. The Articles of Association has completely defined all the activities which the company should perform. The internal rules and regulations, all these things will be specified in the AOA. So every director should be thorough on all the provisions given in AOA. He should work only within the within the ambit of AOA. Whatever is given in the Articles of Association, that only he should perform. He should not make any activities which is not there in articles. So to act honestly to promote the objects of the company. Secondly, the company is an artificial person. It cannot perform the function on its own. So the functions of the company are given to the directors. The functions of the company are performed by the directors. So directors' action should be towards the achievement of the goal of the company. They are objectives of the company. So every act of the director should be directed towards the achievement of objectives of the company. Third one, to carry out duties carefully and diligently. So every act of the director should be very careful. The directors should be very careful in performing these functions, and also they should work diligently. Next one, make sure that his interest is not conflicting with the company's interest, because they are the trustees. The directors are the trustees of the company. Their personal interest should not conflict with the interest of the company. That means whatever work they are doing, that work is of the company. So always try to see that his personal interest and the company interest should not conflict. there should not be any friction between these two. He has to make a balance. He has to make a balance. Next one is not to gain an undue advantage, because his position is very high position, important position, so he should not make any undue advantage of his position. Next one is not to assign office. The activities which are assigned to the directors should be performed by himself. He should not give all these activities to any other person. He should not assign. He only will be responsible. He is accountable for the activities of directors. So these are the general duties which every director must perform. He should perform within the ambit of AOA. He should not do anything which is not there in articles of association. He should act honestly, diligently, and they carry out duties carefully, diligently, and he should see that his personal interest and the company interest should not conflict. He should not take any undue advantage. He should not assign the duties to anybody else. These are the general. Now, special duties of the directors are to make sure that the true and complete disclosure is made in the prospectus. So, before the prospectus is filed with the registrar of companies, the directors must see that everything is clearly stated in the prospectus. Complete disclosure as required by the Companies Act. As required by the Companies Act, everything should be clearly disclosed in the prospectus. He has to see that. Secondly, to make declaration in the prospectus. So before prospectus is submitted with the registrar, he should make a declaration and sign the prospectus. Then what declaration? He has to write in the prospectus that everything has been done according to the provisions of the Companies Act 2013. Next one is to sign the prospectus. Every prospectus before submitting it to the registrar of companies must be signed by the directors. Next one is to submit prospectus to registrar before issue to the public. One of the requirement of the Companies Act is every prospectus must be submitted to the registrar of companies before the prospectus is issued to the public. Next one, to deposit application money in a scheduled bank. One of the requirement of the Companies Act is the application money received, share application money received should be deposited in a scheduled bank. So it is a duty of the director to see that application money is properly deposited in scheduled bank. Next one is to file return of allotment of securities. Once allotment is completed, after allotment completed, a statement that allotments have been done, this statement should be submitted with the registrar of companies to issue share certificate. After allotment, it is the responsibility to see that share certificates are allotted to the shareholders, to sign and file annual return. So every year annual returns will be prepared, and these returns must be signed, must be authenticated by the directors, and then only it will be filed with the respective authorities. Next one, to call AGM. Every year one annual general meeting will be conducted. So directors are responsible for conducting and calling the annual general meeting. Next one, to present the financial statements before AGM. Before conducting annual general meeting, the directors has to see that financial statements are completely prepared, because this financial management has to be presented in the AGM. The financial statements consist of income statement and position statement. Normally we call it as profit and loss account and balance sheet. Next, to suggest a dividend and make payment. Every year dividend has to be declared. The board of directors will suggest a rate of dividend in the annual general meeting, that this year we want to declare so and so percentage of dividend to shareholders. So that suggestion has to be given by the directors in the AGM. Once it is approved, then the dividend will be paid to the shareholders. Next one is to make and prepare and enclose directors report. So every financial statements when presented in the AGM, it should be supported by the directors report. The director's report will be attached to the financial statements, and this should be presented to the shareholders in the AGM. Next one is to submit the financial statement to the registrar. According to the provisions of Companies Act 2013, the financial statement should be presented, should be submitted to the registrar of companies to conduct board meetings. The directors have to see that properly board of directors meetings are conducted. So according to the provisions of the Companies Act 2013, at least minimum one board meeting must be conducted every 3 months. Every 3 months, one board meeting, or at least minimum 4 board meetings must be conducted in 1 year. Then to disclose interest. If in any contract by the company with another person, then the directors have to see whether he has any interest in that contract. If there is interest in that contract, he has to disclose that in this contract I am having so and so interest. So these are the special duties of directors. So what I have explained so far, the directors occupy a very important position in the company management. The company has given immense power to the directors, and directors are the agents, trustees. So law has given him some duties, made them responsible. If they work negligently, without any care, then what will happen? If loss is occurred to the company will sue the directors. That's why a number of duties has been attached with the directors. So broadly two types of duties: general duties and special duties. Just now I have just explained. Now, next question is regarding liabilities of directors. What are the liabilities of directors? The liability of directors can be classified into 2 categories: civil liability and criminal liability. So we divide all liabilities of director into civil and criminal. First of all, civil liabilities. The directors may render themselves liable to the company, to the third party. Civil liabilities are divided into 2. That means civil liability towards the company and civil liability of directors towards third parties. So first we discuss what are the civil liabilities towards the company. The directors are agents and trustee of the company. As such, they owe certain duties to the company. In the last video, I have explained you the position of directors. The director acts as a trustee. The directors are the agents. Agent means the company cannot perform all the functions itself because it's an artificial person. So all the activities, all the functions of the company is performed by director. So director is acting as an agent. So any act of the director is the act of the company. If any wrong is done by the director, then it will be the wrong for the company. So if a company suffers any loss due to wrongdoing of director, then the company will prosecute director. The director is liable to pay to the company. That is a civil liability towards the company. So they are the trustees, because the company has given the money, property and power to the directors. So directors are the trustee for the money, for the property and for the powers given by the company. So as such, they owe certain duties towards the company. Breach of these duties will make them liable. So when they got the power, when the directors got the power from the company, they are liable if there is any breach of duty. If the directors made any breach of duty, they are liable. So they are liable for negligence. If the directors are negligent in performing their duties and on account of that negligence the company incurred loss, in that case it is the liability of the company to pay, to make good the loss which the company has occurred. So a director must exercise due care and diligence in the performance of his duties. Secondly, misfeasance. Misfeasance means breach of duty. Misfeasance means breach of duty in the conduct of company's affairs, which causes loss to the company. If there is breach of duty made by the director, on account of that breach of duty, the company incurred loss. The loss is whatever loss company incurred, that should be made good by the director. The director must pay it. It's a liability. Then last one, breach of trust. The directors are trustees. He should perform for the company. Whatever activities he is doing, the activities are for the company. So if there is any breach of trust, it means any misapplication of funds as director trustee of the company. Trustee in the sense the company has entrusted the money and property in the hands of directors. So directors should not use that money or property for his self-interest. The money and property should be used only for the company. They must exercise their powers bona fide. That means only for the company's benefit, the board of directors should work. Next, Ultravirus Act. Ultravirus Act means any act which is beyond the power of the director. Beyond the power of the director. In articles of association, the powers of directors are specified. So if a director has performed an activity which is not in the articles, it is called Ultravirus Act. Ultravirus Act. So if a director has made any Ultravirus Act and on account of that the company has suffered some loss, so director's liability is to make good the loss. Whatever loss company has occurred on account of this Ultravirus Act, the directors must pay to the company. Where directors do any act which are in excess of their powers or which are ultravirus and the company suffers loss, director should personally liable for making good the loss. So these are the civil liabilities against the company. Now what are the civil liabilities against the third parties, outsiders? So as to contracts, third parties as to contracts, where the directors contracts in their own names without disclosing that they are acting for the company, they are personally liable. Sometimes a director of the company has entered into a contract with a third party, showing that he is doing the contract in his own name. Actually, the contract is company's contract, but he is undertaking the contract in his own name. In that case, whatever is the loss, if there is a loss, then he is personally liable for that loss. Then as to frauds, a director who is a party to a fraud is personally liable to the injured party. So if there is a fraud conducted by the company with another person, that fraud is not of the company, but that fraud is made by the directors, and directors are personally liable for that fraud. Next one, liability under the provisions of the Act. So directors are personally liable to third parties under the Act in the following cases. So three cases are given where directors are personally liable for their acts. The company is not liable. What are the three acts? First one, misstatement in prospectus. The prospectus should be prepared, approved, checked by the directors. If there is any misstatement, misinformation, wrong information given in the prospectus, then directors are personally liable. This is according to the provisions of the Companies Act. Secondly, in case of fraudulent trading, if the directors have made any fraud in trading, then also they are personally liable. Third one, director also incur personal liability for allotment before minimum subscription is received. One of the provision of Companies Act is the allotment should not be done until and unless minimum subscription is received. So if a company has allotted the shares before receiving minimum subscription, then directors are personally liable. So these are the acts towards the third party. So far here I have explained you about the duties of directors, general duties, special duties, and also regarding the liabilities. Liabilities are civil liability. Civil liability towards the company and civil liability towards the third party. Last topic is criminal liabilities. Criminal liability. The liability of the directors are divided into two, civil as well as criminal. So what is the criminal liability here? It is given Companies Act 2013 imposes certain duties upon the directors, and they may be liable to penalties by way of fine or imprisonment. Because the position of the directors is very important, very crucial, because their decisions will affect the company, the shareholders, and the public at large. So they are placed at such a high position that if they misuse the position, they will be punished. If the directors misuse their position, penalties are specified by the Companies Act 2013. If the directors perform this type of functions, not only civil liability but also criminal proceedings will be conducted against the directors. So by way of fine or imprisonment if they fail to perform under Companies Act. The criminal proceedings against director may be instituted in the pursuance of the following sections. A number of sections are given by the Companies Act. In those sections, criminal proceedings can be instituted against the directors. Few examples, few criminal proceedings I have given here under section 34. First, remember, under section 34, filing of prospectus containing untrue statement. If the directors make untrue statement in the prospectus and submitted that prospectus with the registrar, it's a criminal act. It's a criminal liability under section 34. 74. Inviting deposits in contravention of rules. A company invited deposits in contravention of the provisions of the Companies Act. If the directors do that, 7 years imprisonment and fine not less than rupees 25 lakh. The punishment is also specified by the Act, Companies Act, that if a person invites the deposits from the public in contravention of the provisions of the Companies Act, he will be put in jail, imprisoned for a period of 7 years or a fine up to rupees 25 lakh. Under section 26, issuing false advertisement inviting deposits, 3 years imprisonment, 50,000 fine. If wrong advertisement is given inviting deposits from the public, to invite deposits from the public, wrong advertisement is given, again imprisonment is there, fine is there. 36. Fraudulently inducing persons to invest money, imprisonment up to 10 years or fine. Fraudulently, by fraud, inviting the public to make deposits in the company, again imprisonment and fine is there. Section 40. Failure to repay excess application money, imprisonment up to 1 year. It is the responsibility of the director to refund the excess application money. If the directors fail to repay the excess application money, again there is a punishment of imprisonment up to 1 year or also fine. Section 66. Concealing name of creditors, imprisonment up to 10 years or fine. Concealing the name of the creditors. Under section 127, default in distributing dividend, 2 years of imprisonment and fine not less than rupees 1,000 per day of default. So these are only few criminal liabilities. Many criminal liabilities are there. So in order to protect himself, that means the directors should perform his functions according to the law. Whatever given in the Companies Act 2013, that only he should do. Otherwise, he will be liable not only to civil liability but also criminal liability. Civil liability means only he has to make good the loss. Whatever company incurred the loss on account to the functions of the director, that only he has to pay, that is civil liability. Criminal liability means he will be punished by law. He will be punished. He will be made imprisoned. He has to pay the fine. Like that. So, I have completed here the duties of the directors and the liabilities of the directors. So far we have discussed about the duties and liabilities of director. And the last topic in this video is regarding the loans to director. The provisions of Companies Act 2013 regarding the loans given to director. So the provisions of this loan given to directors are contained in section 185. So provisions of loan to directors. The provisions for loan to directors are mentioned under section 185 of the Companies Act 2013. Remember the section number also. According to section 185(1), no company shall directly or indirectly. Remember, these are the wordings given by the Companies Act 2013. You cannot change the wording. So just by heart all these wordings. No company shall directly or indirectly advance any loan, including book debts, or give any guarantee or provide any security in connection with any loan taken by. So this section 185 subsection 1 says no company should directly or indirectly give any loan, advance any loan, including book debts, or give any guarantee or provide any security in connection with any loan taken by any director of company or of companies which holding company or any partner or relative or any such other director or any firm in which such director or relative is a partner. That means according to these provisions of section 185(1), no company should directly or indirectly give any loan, give any advance, any loan, including book debts or guarantee, provide any guarantee or provide any security in connection with the loan taken by any director. That means the company should not give any guarantee, should not give any security for loan taken by any director of the company or company in which holding company or any partner or relative of any such director or any firm in which such director or relative is a partner. These are the provisions given under section 185. But such loans or guarantee can be given in connection with any loan taken by any person in whom director of company is interested if. So now the section says the company can give the loan, provided some conditions are satisfied. The conditions are special resolution is passed in general meeting. So when the company has to give the loan, the company has to pass a special resolution in the general meeting, first condition. Second, loans are utilized by borrowing company for its principal activities. So presently, the company cannot give directly loan to the director, but the company can give the loan to a company, to another company, loan to a firm in which directors are interested, provided a special resolution should be passed. And also we have to see loans are utilized by the borrowing company for its principal business activities. Only for the principal business activities loan is taken. Then only loan can be given by a company. Thus loan can be given only to another company, not to a director or his relative or any firm. The loan can be given only to a body corporate, only to another company. Now restriction not available to specified private companies. This restriction what is given under section 185, that restriction is not applicable to some private companies. So which private companies here? The restriction under 185 of Companies Act 2013 are not applicable to private companies in whose share capital body corporate has not invested any money. That means any private company in that no body corporate has invested the money. That means no other company has invested the money in this private company. Secondly, which has borrowing from banks and financial institutions. FI stands for financial institutions, or any body corporate not more than twice of their paid up share capital or rupees 50 crore, whichever is less. So second condition, second thing says which has borrowing from banks, any private company. Any private company which has borrowings from banks or financial institutions, any body corporate not more than twice of their paid up share capital. That means borrowings should not be double the paid up share capital or rupees 50 crore, whichever is less. So in these two circumstances, the restrictions given under section 185 not applicable. First one, it should be a private company, and next one in whose share capital no body corporate has invested the money. Next one, in this case, the borrowings from banks or financial institutions should not be more than twice of the paid up share capital or rupees 50 crore. Now private company is not in default of repayment of such loans. Third point, the private company should not made any default in the repayment of the loans, borrowings. Thus, public company can now give loans, provide security or grant guarantee to the body corporate. So at present, what is the rule regarding the loans given to director? Directly it cannot give the loan to director, but it can give the loan to body corporate. Body corporate in which directors are interested. But the condition is grant guarantee or body corporate from which its director is interested by passing special resolution. First condition is the company, before lending the loan, the company has to pass a special resolution. And secondly, depicting that the amounts are used for principal activities of the business. When the company is extending the loan to another body corporate, two conditions are there. First condition is we have to pass a special resolution that the company is giving a loan to another body corporate. Secondly, we have to see that the other body corporate is utilizing the loan amount for its principal business activities. That's it. So these are the provisions regarding loans given to director according to section 185. So in this video I have explained you about the duties, liabilities and loan given to director. The provisions regarding duties of the director, liabilities of the director and also regarding the loans given to director. That's it. So next video, inshallah, I will start the next topic. So if you are satisfied with my lecture, give a like to the video. Share my channel in your group, in your friend circle so that more students can watch the video and enhance the knowledge. Give your comments on these videos, and lastly, don't forget to subscribe my channel. Still more than 50% of my viewers have not yet subscribed. I don't know why. What is the reason? Getting the views. That means viewers are increasing, views are increasing day by day, but subscribers are crawling, not getting the subscriber. So anyway, if you are satisfied with the lecture, it's okay for me, even if you don't subscribe also. So inshallah, I'll continue in the next video, the next topic on company management.